Welcome to Brief Encounters. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, and I'm also the leader of the Securities, Regulation, and Litigation practice at the firm. I'm super excited to co-host Season 2 of our Securities, Regulation, and Enforcement series here on the DC Bar Brief Encounters podcast. And back for Season 2 is also my co-host, William Nelson. William, can you go ahead and introduce yourself?
Yeah, hi, William Nelson. I'm the Director of Public Policy and Associate General Counsel at the Investment Advisor Association. And yeah, Valerie, it's so exciting, finishing up first season. And I think we're, in for a real treat today too, starting out Season 2 with a bang, I think. So really looking forward to it.
Absolutely. So even though we're starting Season 2, we're picking up at the end of our last two episodes, where in November and December, we focused on the presidential transition. And we're recording this on January 17th, 3 days before inauguration. And of course, our focus is not just on the presidential transition and the inauguration, but also the impact on the SEC. So this episode will come out early February. So there'll be about a couple weeks between today and when it's out. But we're really going to continue our conversation on what does the transition look like at the SEC? How does the building keep moving and stop? And I think we have the perfect guest for that. So William, can you go ahead and introduce our guest?
Yeah, absolutely, Valerie. And we're so excited today to have Pete Driscoll joining the podcast. Currently a partner at PwC, but prior to that served as the director, formerly the Office of Compliance Inspections and Exams, OC, now the director of Division of Exams, where he led a team of over 1,000 accountants, attorneys, examiners, has 20 years of experience at the SEC. Again, just a real all-star. So we're so excited to have you, Pete.
Oh, it's a huge privilege for me to be here today. I listen to your podcast each month. I got to say that, to me, you hit all the current topics, you hit them well, and to include me is something I hadn't foreseen, and I'm very delighted to be here.
Well, we're super delighted too. So Pete, you were on the staff for quite a long time before you became the director of exams. So you saw several transitions. And I was wondering if you could walk us through our day, what's different and what's the same? Is it very rooted in it's a transition no matter what? Is it more of a transition when the White House flips and it's a party change? So I'd love to start there.
Yeah, and I'll bring a couple different perspectives. So I spent 12 years in a regional office, and then I spent my final 8 years out in DC at headquarters. And so I think at a regional office, I saw a number of changes, both with the chair role, but also chairs from different parties that were appointed by the president at the time. And I will say in the regions and at a staff level, you don't see big changes filtering down as much as I did when I was in DC in more of a leadership role. Because, particularly in enforcement and particularly in exams, a lot of times cases continue, exams continue. Generally, the main priorities of cases at the SEC from an enforcement perspective, they're looking at fees and expenses, disclosure, accounting fraud, Ponzi schemes, insider trading cases. A lot of those transcend political changes within the building and within the SEC, within the agency. And similarly with exams, they have the core exams and the risk process about what they're focused on. They're focused on, for investment advisors, conflicts of interest. They're focused on fees and expenses. For mutual funds, they don't do a lot of exams in the mutual fund space. They only do about 120 a year. And like I used to tell people, for me, that was the lowest risk area that I was responsible for, because the governance and the third parties that are involved in the mutual fund space is so high that, it's just a lot less risk than, say, a pure investment advisor or, a broker dealer, even though there's FINRA there, broker dealers that have a lot of representative offices and branch offices throughout the country. And so, you really see the core continuing, I think there's certain priorities that come up depending on, and I'll give you examples of most recently. So you have AI as a priority for exams and some enforcement investigations. ESG has obviously been an important priority over the last 4 years. I think what you'll see in turn, it'll be softer, but it will be more AI washing, greenwashing, the real fraud, which, whether it's in the ESG space or the AI space, or whether it's somebody who's touting the latest, greatest investment strategy that involves small caps or mid caps and their disclosures are misleading. Those cases are still going to continue. I think where you'll see policy changes, and right now, all the divisions are preparing a briefing book for the incoming chair. That briefing book will have statistics about the staff in those particular divisions and offices. It will have priorities that they're focused on. For exams, it's the makeup of the regional offices, how many exams they're doing, the types of referrals to enforcement that they have. You'll see a large, briefing book process in each of the divisions and offices for when, the next chair comes in, which, is looking like it's going to be Paul Atkins. He's an insider, like he's been at the SEC for 6 years prior. Actually, more than that. He was a commissioner for a period of time, but then he was also on staff. And so he'll have some good working knowledge of inside the building. You'll also see right now a solicitation of feedback, both from staff as well as from folks outside the building, of certain pain points that may be resolved through changes within enforcement exams, changes within policy approaches. If there's certain rulemakings that, should be taken up to solve certain issues that are taking place, that approach is going on. I would say right now, I think rulemaking pencils are down, but I think with exams and enforcement, they're still continuing. I mean, we're seeing a large push of cases to come out before the inauguration. And you're seeing a lot more actions hit before. And, you just saw recently like off-channel communications. I think it's clear that, come January 21st, they're not going to be bringing many, if at all, any off-channel communications because it doesn't fit the mold of a Republican approach where, there's no investor harm. It's more of a record-keeping type of case. You'll still see exams look at things like that, but you're not going to see it to the level of, heightened scrutiny that it's received over the last couple of years.
Yeah, Pete, that makes a lot of sense. And, something you touched on with Paul Atkins, we think will be the SEC commissioner, and again, until he's obviously confirmed. But, I'm curious, just with your breadth of experience, is there anything unique about this transition? Just thinking about just the stark differences between the administrations. I know, we've had, party changes, Republican to Democrat, Democrat to Republican, but it seems like in this instances, there are pretty stark differences between the personalities of, the current chair and then the potential incoming chair. So I don't know if you could just talk a little bit about that, if you see anything, it's kind of unique maybe about this upcoming transition.
Yeah, no, it's a great read, William. I completely agree with you in terms of just the differences in approach that I think will be taken. So I worked for Jay Clayton, and then I worked for Gary Gensler for a period of time before I left. And prior to that, I assisted with the incoming of Mary Jo White. And each one of those transitions, you saw different personalities and priorities come in. And in some cases, it was very clear from the start. In other cases, it was a little more subtle. And so, I think what you'll see from Atkins, assuming he gets confirmed, is that you're going to have somebody who's been at the agency, knows the agency, and knows a lot of the people and knows a lot of the point issues coming in and hitting the ground running to make either organizational changes or policy changes and policy changes from the start. Whereas in some cases, it took a few of the other chair coming in to get to know the agency a little bit, to understand that, there's a union that represents employees, to understand the makeup and the different organizations within the SEC, whether it be through a region and its interplay with the headquarters, as well as all the divisions and offices that, there are over 25 of those. And so it's a pretty vast organization, both geographically, but also, topically. And so I think you'll see, someone who understands all that already. And so I think, he'll get to business very quickly. And it can be subtle. Like, I think day one, they'll pull the formal order delegation to the regions, which is something that's typically done in a Republican administration, where, when it's delegated, when that authority is delegated to a regional office, they can open up an investigation on their own. However, when that delegation gets pulled centrally, I know under Jay Clayton with Steph Avakian and Steve Pekin, that approval for formal order to open an investigation, that was done centrally in DC. And part of that is to help ensure that, the cases that are being opened are consistent with the priorities of the new administration and whoever's in the chair seat. I think you'll see things like CCO liability, the interest in that get pulled back and a more of a protection of the chief compliance officer role within organizations. I think board of directors and trustees liability, I think you'll see more protection of the boards and helping them execute their roles without fear of potential getting second guessed in liability from an enforcement or frankly from an examination perspective. I think you'll see those changes as well.
That all makes a lot of sense, Pete. And, I think has been our experience for those of us who've practiced in DC, both at or near the commission and near the SEC. So really, things get much more centralized at the beginning of a Republican SEC, so to speak.
Exactly. One of the things that I really focused on when I was director of exams is, it's hard to manage a large decentralized program where you have 1,000 people all across the country working out of, at the time, it was 12 different offices. Now it's down to 11. And ensuring that the work that they're doing is consistent with the priorities and consistent with where my boss, who was the chair, wanted the agency to focus on, whether it, for Jay Clayton, it was retail investors. It wasn't the private fund space, although we did private fund exams at the time. I would envision, particularly after the recent court cases, that there'll be a real pullback and focus in the private fund space to the point where, I think they're right now probably questioning whether or not exams keeps its private fund unit, or do they return those examiners to the core program, particularly given the PFU has been in place for close to 10 years and is likely, served its purpose. So it's things like that. And I think that they may look at the specialty units that are in enforcement to see if those still make sense based on the subject matter that they were focused on, and if those still remain priorities to the incoming chair in the new administration.
And that makes complete sense too, because I remember when the PFU was stood up, it was really because there was such an influx of new private fund advisor registrants as a result of Dodd-Frank.
Exactly. And, and we were talking thousands of new advisors registering. And at the time, a lot of the examination staff didn't have that expertise. And so, they hadn't seen a lot of private equity firms and potential quant shops and hedge. And so with this influx of that new type of registrant, the SEC we had to go out and hire experts from industries to help us understand how these firms operated. But now they've been registered for over 10 years. And so I think there's a view there and a working knowledge that most examiners have of the nuances in each of these different types of, all businesses.
Right. No, that makes complete sense. And our regular listeners know, we generally have some sort of Dodd-Frank component to the podcast topic, not always, but often. And yet we somehow found one on this one, even though we were not actually planning to. But that's right, because exams really evolved as a result of the influx of new private fund, hedge fund, PE fund advisors who all had to register as a result of Dodd-Frank, or many of whom had to register. Many were already registered.
That's right. And it was a new type of client for the SEC to get their hands around.
And the risks are different.
Exactly. Yeah. You think about PE and, a lot of private investments, hard to value. Valuation becomes a big concern. The structures for fees and expenses are very different. And I think that you'll see a pullback in focus from those types of organizations. One thing, and I love your podcast. And so you talked about cybersecurity, and particularly with Sarah Krovitz in terms of, what the cybersecurity rule for advisors and funds, why that wasn't finalized. And, I will tell you that the breadth of that rule, it captured all 15,000 plus investment advisors. And when I was running exams, the thing I cared about were large firms that had millions of customers that had outages or had some sort of ransomware event. And, because of the breadth of their firms and their exposure to the investing public. But also the thing I was worried about was contagion, where multiple firms had outages at the same time, impacting millions of US investors and their ability to get into their accounts, to execute trades. And I think what I did not care about were smaller investment advisors. Not that I didn't care about it, but it just wasn't as high a priority in a risk. If a private equity shop went down to a ransomware, sure, I cared, but it wasn't to the point where I was worried that it was going to impact and ripple across the entire markets. And so I think, if you see that rule amended or reproposed, you will likely see it reproposed for only the large investment advisors and mutual fund shops that, face millions of investors, and more for, we've gotten into, like, when I was running exams, it was very much cyber, we looked at firms as victims. And I think that that's changed in tone over the last several years. And I would like to see a return to, hey, we're all in this fight together against state actors, cyber criminals, and let's help each other defend and protect the investor, as opposed to playing gotcha with firms that do get hacked or ransomware. And particularly in the smaller shops, I just don't think that rule made sense in that space, both from a cost perspective, but also from a risk perspective.
No, I think you're exactly right, Pete. And we were kind of 50-50 whether a component of that rule would survive and be finalized before the end of Chair Gensler's term, because of course he's stepping down on Monday, January 20th. But your point about tone is so true, Pete. Most of my practice is enforcement defense, and that idea that a firm could be a victim just as much as investors in a cyber scenario really has got lost in the last few years. And I really hope there's more of this. We're all in this together, the way you described it.
Yeah, Valerie, and I think we take the similar perspective as well. I think, Pete, you really put it really well, kind of differentiating between, individual firm risk versus, that more systemic market risk, and really looking at the magnitude of, some of what the cyber breaches really, could wreak havoc with the market.
Absolutely. No, completely agree.
So again, this has been a wonderful conversation, Pete. And, kind of speaking of the very stark differences, we discussed previously between Chair Gensler and the potential incoming chair Atkins, is the issue of digital assets and cryptocurrency. We have seen just a proliferation, both in the media, but also, investor interest. And I know, the incoming administration has stated that it is going to be kind of a day one priority. We've heard of a potential executive order on digital assets and cryptocurrency. In Congress, we have a new financial services chair French Hill, very interested in the digital assets and cryptocurrency space. So I just kind of, would love to pick your brain, just kind of looking at maybe what are some of the things that may happen quickly at the SEC in the crypto space, but then maybe just some of the more long-term policy priorities you might see.
Yeah, I think, and you're right, I think we're going to see a lot of change there. I think one change that is not limited to digital assets, but I think it certainly will be a priority, is a lot more receptivity to having conversations to identify the issues that would be of concern to the agency, like safeguarding of assets and custody of digital assets, and working on solutions with the industry to provide greater access for people to invest in a way that there are some guardrails to help with investor protection. I think Paul Atkins and, particularly Commissioner Peirce and Commissioner Mark Ueda have indicated just, there needs to be more discussion and a collective solution. And I think a lot's changed in the last 8 years, with Gensler and then with Jay Clayton. In terms of the service providers, I know, the audit firms have figured out how to audit digital assets and things to look for to ensure, the safeguarding of assets, particularly in the private fund space, because they were early adopters of investing in digital assets for investors. Now you're seeing a move into exchange traded products. And so I think it's becoming more mainstream. And I also think that there's intermediaries that have improved controls, gotten, SOC reporting from an internal control perspective to help shore up some of the concerns and potential control weaknesses that would help prevent harm and loss of, investor assets, through a loss of a key, through the loss of, a laptop or something that contains information that's non-recoverable. I think there's just a lot more thought that's been put into it, which will likely make it easier for more mainstream approach by the SEC to regulate this in a way that's more reasonable than just saying no.
No, I think that's exactly right, Pete, especially because this is, at the end of the day, an asset class that the market wants access to.
Exactly. I mean, it's there's a lot of asset classes out there, and oftentimes there's segments of fraud in each of them, and fraud is fraud, no matter what type of asset it is. And that's the bread and butter of what the SEC does, is they bring cases against the outliers who try to cheat investors, steal money, things like that. And that's such a low percentage of the industry as a whole. And so I think that you'll similarly see that in the digital asset space, where it becomes a more mainstream asset, where a lot more people can invest in it as part of an asset class, and there'll be more governance in place to protect them.
Yeah, and I definitely think all that makes sense, Pete. And then, we've already kind of seen, the movement towards that, with the Bitcoin ETF approvals and, trying to get, those more retail investors access to cryptocurrency and digital assets through registered products. But I think there will be a even greater movement now to really kind of try to even more mainstream. And we've also seen, some firms also, that were kind of sitting on the sidelines before, just with all the uncertainty, now really saying, hey, let's get something done.
Another area that I just raised that I'm hearing a lot about is the retailization of the alternative space and the private fund space. I think you'll also see a lot more interest and receptivity to bringing those asset classes of the alternatives to a more mainstream investor, because oftentimes a lot of mainstream investors cannot invest in private funds because they don't meet certain requirements from a sophistication perspective. And so I do think that you'll see more willingness to have alternatives in public funds to provide that asset class opportunity for retail investors.
Pete, I think that's exactly right. And it also reminds me of some of the policy dialogue about 10 years ago around just more generally Reg D Rule 506 offerings and whether they should be easily available to retail investors.
Exactly. And, I've heard rumblings that they may look at those definitions again to broaden them to allow for more access.
So, William and Pete, I think we're coming up at the end of our time together. Any last comments or parting thoughts before we wrap up?
I think it will be an exciting time. I think anytime there's change, I think some people get a little nervous one way or the other, but I do think that you'll see different initiatives. I think us as an industry and service providers for the industry, as well as advisors to and the voice of the industry, I think we'll have a lot of opportunity to dialogue with the new administration to help fix pain points. And honestly, I think you'll see a little bit more of a return to the core business of what the SEC focuses on, which includes investor protection, but that capital formation piece, I think you'll see a lot more receptivity to that prong that the SEC promotes.
And I think that is a very good thing. William, any last thoughts before we wrap up?
Yeah, just a huge thank you again to Pete for being on, providing your expertise. It's been wonderful. And I completely agree. I think this is going to be a really exciting time for innovation. And hopefully, we'll have a lot of more fun podcasts this year and different topics that pop up. But again, thank you so much, Pete, for participating today.
Yes, thank you, Pete.
Oh, it's my pleasure. And I look forward to listening to them. Thank you both for having me.
Thank you. And till next time.